Supreme Court Justice Sotomayor issues blistering dissent, says Republicans appointed justices have bias towards the Trump administration. So, as you may have heard, Trump doesn't like the courts, and the courts don't particularly like Trump. Most recently, Supreme Court Associate Justice Sonia Sotomayor issued a scathing rebuke of the court's decision to allow the Trump administration to enforce its public charge rule in the state of Illinois, limiting which non-citizens can obtain visas to enter the U.S. So, quick background on that case. Basically, the public charge has been in federal law since the 1960s, but it's never been really defined. So Trump issued a rule that defined it, and of course, it was instantly taken to court because enforcing American laws is terrible, and restricting people who can come into this country to anyone who doesn't instantly need welfare is clearly abusive and detrimental to the rest of the world, because we're not really supposed to stand up for America. But back to the Associate Justice. Sotomayor's problems with the conservative majority ruling went far beyond this case, claiming that it was symptomatic of the court's habit of siding with the government when they seek emergency stays of rulings against them. Her dissent said, "It is hard to say what is more troubling, that the government would seek this extraordinary relief seemingly as a matter of course, or that the court would grant it," Sotomayor wrote in her dissent. This particular case, Wolf versus Cook County, deals with the Trump administration's expansion of situations where the federal government can deny visas to non-citizens looking to enter the U.S. Federal law already says that officials can take into account whether an applicant is likely to become a public charge, which government guidance has said refers to someone primarily dependent on the government for subsistence. In the past, non-cash benefits such as Medicaid and certain housing assistance did not count, but the Department of Homeland Security issued its new public charge rule in 2019, which did include these benefits. The new rule has previously been blocked with a nationwide injunction that the Supreme Court stayed in a separate case, so the injunction in Cook County case only affected the state of Illinois. That narrow scope, plus the fact that the Seventh Circuit is scheduled to review the Illinois injunction in the coming week, led Sotomayor to believe the government was not at risk of suffering significant harm that warranted the Supreme Court putting the injunction on hold. The liberal justice expressed concern that a majority of her colleagues had no problem with this. She explained that it is unusual for an administration to seek stays against injunctions with this sort of frequency, yet is becoming the new normal. Claiming one emergency after another, the government has recently sought stays in an unprecedented number of cases, demanding immediate attention and consuming limited court resources in each, she wrote. And with each successive application, of course, its cries of urgency ring increasingly hollow. Indeed, its behavior relating to the public charge rule in particular shows how much of its own definition of irreparable harm has shifted. So, Trump has gone to the Supreme Court for immediate stays, but that's probably because he's had more nationwide stays put against his rulings than anyone else. If we go to former Attorney General Jeff Sessions, may he rest in peace in whatever he's doing. I think he's running for Senate now. In a speech to a conservative legal group Saturday, this was originally dated 2018, Jeff Sessions blasted federal judges for issuing nationwide injunctions that blocked President Donald Trump from enacting his policies on everything from sanctuary cities to transgender troops serving in the military. So, during his time, Trump has had approximately 22 nationwide injunctions put up against him on everything. Since taking office last year, Mr. Trump, so between 2017 and 2018, has been hit with 22 nationwide injunctions. That exceeds the number of injunctions issued by nation's courts in the past 200 years. And what states are those coming out of? Just guess. California, Washington, D.C., Hawaii, Oregon, Chicago. In roughly 1 year, judges have issued nationwide injunctions halting Mr. Trump's efforts to implement a travel ban, which was ruled constitutional, phase out DACA. So apparently the president can't phase out another president's, executive order, which basically means the executive order is a law that cannot be rescinded. Withhold federal grants from sanctuary cities who are violating federal law, so if they don't comply with federal funding or federal laws, you still have to give them federal money, which is amazing because In certain other programs like No Child Left Behind, for instance, if they don't comply with federal laws, they lose their funding. So kind of weird on that. Reinstate the ban on transgender troops in the military, which is well within his rights because he is the commander-in-chief, and running of the military is outside the purview of the Supreme Court. And of course, change the Obamacare contraceptive coverage mandate, because it violates certain people's religious beliefs. And of course, Obama was all about granting exceptions to everyone at the flick of a pen, but when Trump tries to do the same thing, it's somehow unconstitutional. Which brings us to, why is this happening? What's going on with our judiciary? Why does it matter? So, most recently, judge halts plan to move virus patients to California City. So if you don't know, the coronavirus is outbreaking. Most recently, the State Department brought cases back to the United States. Trump didn't know about it. He didn't know they were infected. He flipped out. Is it a case of, hey, they didn't have symptoms at the time, we didn't know? Or is it a case of, as usual, people in the State Department not caring what the president says, and we know what's best for the country, so, we're the State Department. In my personal experience, the State Department cares about one thing, the State Department, and getting their paychecks. All right, so Costa Mesa, California. Court temporarily blocked the U.S. government from sending up to 50 people infected with a new virus from China to a Southern California city for quarantine after local officials argued the plan lacked details on how the community would be protected from the outbreak. A federal judge issued a temporary restraining order late Friday to halt the transportation of anyone who has tested positive for the new coronavirus to Costa Mesa, a city of 110,000 in the heart of Orange County. U.S. District Judge Josephine Stanton scheduled a hearing on the issue Monday. Now, Costa Mesa's defense, they also are a city that is protesting California's sanctuary city law, so they don't believe in sanctuary cities. So they do actually want to protect their city, and that's fine. But I was wondering what else this judge ruled. Do I think the city should be consulted? Yes. Ultimately, does the federal government have to have some discretion? I mean, they have to go somewhere. The DOD says they can't stay on the Department of Defense because it's going to jeopardize readiness, which is kind of an issue for them. So they have to go somewhere. So I looked into the judge. You Google her name. This same judge said the Second Amendment does not protect semi-automatic killing machines. So if you don't know what a semi-automatic rifle is, it's a rifle that loads another round every time you fire it, which is about 95% of all the rifles in America that are sold. It's basically a modern firearm, right? These became basically standard in, the late 1800s. U.S. District Judge Josephine Stanton, Central District of California, ruled this week the existence of the Second Amendment does not mean semi-automatic killing machines must be legal in California. Stanton ruling against semi-automatic rifles with non-fixed magazines came in response to a California Rifle and Pistol Association challenge against the state's assault weapons ban. Now, in a previous ruling, which we'll probably get to earlier, Heller, they said they should be covered. CRPA sought a summary judgment against the assault weapons ban on behalf of plaintiff Stephen Rupp, but Stanton rejected the summary judgment request characterizing semi-automatic rifles with non-fixed magazines as killing machines, which are essentially indistinguishable from M16s. Not true, in a way. Stanton's point overlooks the fact that M16s are fully automatic firearms. Not true, they mostly fire on burst, right? You got safe, semi-automatic, and then burst fire, which fires 3 rounds, which can fire a magazine full of bullets per 1 trigger depression, which is not true. Literally not true. Well, AR-15s are semi-automatic rifles which fire 1 round per trigger pull, period. Her position aligned with that of California Attorney General Xavier Becerra, who argued an assault rifles may be banned because they are like the M16 weapons that are the most powerful in military service, and they are also not in common use for lawful purposes like self-defense. But they are in common use. Stanton opined that a ban on M16s can stand under scrutiny of District of Columbia versus Heller, 2008, because such guns are outside the scope of the Second Amendment. She then turned to a ban on AR-15, saying, thus, if a weapon is essentially the same as the M16, it is not protected by the Second Amendment merely because gun manufacturers have given it a different model number and dubbed it a civilian rifle. Alrighty then. So let's look at what the Constitution says, because it's real simple for the judge. Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. But what does that mean? Let's help the judge out. Arms, instruments or weapons of offense or defense. That sounds like a powerful military weapon. It sounds like the founding fathers, who had fought 11 years for an American independence, wanted people to be able to own weapons that they could defend and fight off a foreign power. Seeing as how the first armed resistance against the British was by militias using the best weapons they had available, it kind of makes sense why they think that might be an important thing. But the judge apparently thinks that having weapons that are powerful is not in the Second Amendment, which makes me question her understanding of the Constitution. But that's okay. So what are some other famous rulings she's had? If you don't remember this one, 21 young people sued the federal government in 2015 hoping to force an end to fossil fuel-friendly U.S. policies. The Ninth Circuit has thrown that course out. The Federal Appeals Court tosses landmark youth climate lawsuit against the United States government. January 17, 2020. Federal Appeals Court on Friday threw out a 2015 lawsuit by nearly 24 young people to force the U.S. government to take more aggressive action on climate change, saying that their children did not have legal standing to bring the case. Judge Andrew Hurwitz wrote that the plaintiffs had made a compelling case that action is needed to slash the greenhouse gas emissions that contribute to global warming. But the three-judge panel of the U.S. Court of Appeals for the Ninth Circuit ruled 2-1 that the courts were not the place to compel such actions. We reluctantly conclude, however, that the plaintiff's case must be made to the political branches or to the electorate at large, the latter of which can change the composition of the political branches through the ballot box. In a blistering dissent, of course, our Second Amendment-loving District Court Judge Josephine Staten served on the panel, criticized the notion that the courts have no role to play, saying the government itself has acknowledged that the United States has reached a tipping point, crying out for concerted response, yet presses ahead towards calamity. It's as if an asteroid were barreling towards Earth and the government decided to shut down our only defense. Seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation. My colleagues throw up their hands, concluding this case presents nothing fit for the judiciary. Yeah, they probably don't there, Judge. The courts are there to interpret the laws. The courts are not there to compel the government to pass a law based on whoever sues. So this judge's position is that 21 children should be able to sue the federal government to force the House of Representatives and the Senate and the President to sign laws that they believe are appropriate. Because, 21 children are super experts. I would love to be in the room when only those 21 people, those 21 kids, were telling the government how to write the laws. Like, I would love to see how this plays out in this judge's mind, where she's like, the judiciary, yeah, hey, listen to these 21 10-year-olds. They're going to tell you how to fix the environment because they understand it. That's not a train wreck. This lady is the definition of judicial activist. Like, her understanding of the Constitution is extremely frayed, and her understanding of the separation of powers and the organization of our government is slightly skewed. But that's okay. Trump's in office. He's doing gangbusters on appointing judges. As you can see from this, in the first 3 years, Trump has appointed 28% of circuit judgeships and 21% of all judgeships, which is blowing everyone else out of the water. Hopefully he gets another 1 or 2 Supreme Court picks, because the Democrats have been using the courts and activist judges and court shoppings to come up with some insane laws. If you want an eye-opening case of why judicial activism is bad and why we need judges who believe in the Constitution and not the rule of politics, just go to your favorite search engine and type judge rules against, and just start looking at some of the things they're ruling against and some of the things they believe in. If it was up to some of these judges, America wouldn't have borders, we wouldn't have a military, we wouldn't have, law enforcement, and they would basically be telling everyone what to do. It's insane. But thanks for watching. Leave feedback, subscribe, or don't. Like. Have a good day, and I'll see you next time.